Welcome to this edition of Security and Compliance Weekly. Today, we're very excited to welcome our rotating co-host, Priya Chaudry, back to the show. Priya's got some fascinating legal issues to discuss around security, compliance, and, of course, law. She is a lawyer, after all. We're dedicating the whole show to the conversation. We've got some wonderful topics, and we need that whole show because these topics are going to be fun. So join us as we continue our journey of tearing down silos and building bridges on Security and Compliance Weekly.
This is a Security Weekly production. And now, it's the show that bridges the requirements of regulations, compliance, and privacy with those of security. Your trusted source for complying with various mandates, building effective programs, and current compliance news. It's time for Security and Compliance Weekly. Are you struggling to reduce your cybersecurity risks and meet compliance mandates? Wishing you could be proactive instead of reactive? You need a solution that integrates cybersecurity together to make it affordable, accessible from anywhere, and simplistic, so you can gain a return on investment on your resources. Cyrisma is your answer. It gives you a single interface to identify sensitive data, vulnerable systems, insecure configurations, track progress, and assign accountability. Visit securityweekly.com/Cyrisma today for a 7-day test drive and impress your leadership. That's Cyrisma, Cyrisma.
Welcome, everybody. This is episode 61 of Security and Compliance Weekly, recorded on the 9th of February, 2021. I am your host today, Joshua Marpet. Mr. Jeff Mann is out today due to some training things that he has to do. And matter of fact, they're PCI training things, which makes me giggle inside, and I hope does for you as well. With me today are my illustrious co-host, Scott Lyons, and our rotating co-host, Priya Chaudry. Welcome, everybody. If you're not on the Discord, please get on the Discord. This is going to be an incredibly lively discussion. We're going to have so much fun.
Oh, man.
All right. Some announcements. Do you have a specific guest or topic that you want us to cover on one of the shows? Submit your suggestions for guests by visiting https://securityweekly.com/guests and completing the form. We review suggestions monthly and will reach out to you once reviewed if we need any more information and to say, yes, we're going to take them. As well, if you've missed any of our previously recorded videos, webcasts, technical trainings, whatever, they're available for your viewing pleasure. For the webcasts and technical trainings, go to securityweekly.com/on-demand, one word. All right. I am very excited to welcome Priya Chaudry to the show as her turn in the barrel. Co-host seat. Sorry. Priya, welcome. Welcome back. Actually, what is this, your fourth or fifth time on the show?
I think fourth, but with pandemic time, it could be 400. I'm not sure anymore.
Yes, I haven't left the house in 6 years, 7 years. I don't remember anymore, you know. But, every time we have a guest on, we ask the hot seat question. And you've answered it before, but I have to ask this. I'm curious, being on the show, seeing the show, researching some of these topics, has your answer to the hot seat question changed over the years?
I forgot what the question was, so I'm sure it has.
That would help. I'm sorry. So our hot seat question is, what is your opinion on security and compliance and the relationship therein?
Oh, yeah. So absolutely. Researching these topics has made me understand in a way I think I didn't really focus on before, how these are not topics just for people in the security industry or lawyers, but these are topics that trickle down to every person that is using the internet in any way, and how they've become pretty much fundamental privacy, freedom issues that go much bigger. It's almost like the very core issues that the Constitution was set up to address, of what is the role of people's own privacy in a government and in a system where we're organized together. So yeah, absolutely. The more I look at this, it's so fascinating. It's really interesting.
No, that's really cool. And that really rolls right into the topics you brought. So this is fantastic. I mean, you're right. Security and compliance and law really have a lot in common, and they relate and are relevant to so many more people than believe they are. I'm enjoying this already. This is great. This is going to be a great discussion. All right. So Priya, you brought 3 topics. to the table, if I remember correctly, 2 scraping cases, and then, of course, SolarWinds, because we've never talked about SolarWinds. We need to talk more about SolarWinds. Nobody here has talked about SolarWinds enough, right? I mean, let's be clear. So can I ask you to sort of introduce the topics, and let's get started?
Yeah, so I think SolarWinds is a little different, and it's interesting the SolarWinds issue is this. SolarWinds is a company that sold a product. That product was used by all sorts of big other companies, including the US government, other governments, Microsoft, etc. SolarWinds had an update that one was required to use, and when you updated it, it invited hackers into your system, and therefore those companies had security leaks caused by a hack into SolarWinds that went into the company. We'll just use Microsoft here. And then the Microsoft end user who had data with Microsoft now was jeopardized. So the first fallout was pretty obvious, which is the companies that had bought the SolarWinds product were affected by this hack.
Right.
The next issue, which is what this lawsuit is a little different, which is the lawsuit is a class action lawsuit, meaning a group of people who have the same interests, instead of bringing a number of identical suits, are bringing one big suit that's supposed to represent everybody's interests. And those are the people who own stock in SolarWinds and who bought that stock between like February and December of 2020. And so this is sort of interesting because it's obvious to everyone sitting at home that if you have data with Uber and Uber gets hacked, now your data has been compromised. And Uber has a problem with you, the user whose data got hacked. Now we're talking about companies who have a product that other companies are buying. And the stockholders of that company, so you're a publicly traded company like SolarWinds is, and the people who own your stock are saying, actually, you're also liable to us because you were not thorough enough in protecting the product that you put into the marketplace. And because you were not thorough enough, you made essentially misrepresentations in your public filings. And because of your misrepresentations, I bought your stock and I have lost money because had you done your work, then I may not have bought my stock because I wouldn't have thought your company was as good as it was. So this I think is just fascinating because if you are someone out there creating a product like SolarWinds and you want to have a big company, where you're trying to go is this becomes a publicly traded company, right? That people are buying in, and that is the value of your company because all these people have bought shares, and that becomes a representative value of your company. And now what the SolarWinds class action is saying is that company has to be worried that its own investors might sue it for not doing everything possible to protect against possible hacking. I'll stop there because I think you might have some questions I want to jump.
Yeah. So we've got a company that makes a product, and that product is used by other companies. But the product company has sold shares. They're a public company.
Right.
And because they didn't do everything possible, and I'd love to know who defines everything possible, because that's my first question. But they didn't do everything possible to prevent hacking. They're being held liable. Their market cap, their, and I muttered, by the way, while you were talking, shares are how you define value, and well, except for GameStop, but that's a whole different story. But because they didn't do everything possible, air quotes, for those of us not watching, their market cap, their market value went down, and people are suing to recoup that. I mean, isn't the stock market a gamble anyway? Doing a class action lawsuit against somebody who, what you're saying is there's negligence involved. They didn't do everything possible. So if there's negligence involved, I can sue for the loss of my stock or the loss of my stock value. Is that a little crazy, or am I misunderstanding?
All of your questions are the right ones. So if you have a publicly traded company, I'll back up. The underlying question in all of this is, how should the government protect people, right? If you're out in the marketplace and you are buying securities, whether or not you know it, the government is really involved in that transaction. If a company is listed on any sort of stock exchange, it has to agree to comply with certain rules. So the government does, everyone who's like get away with government, free markets. That's all a joke, because the government is involved in the market to make sure people who are, mom and pops, grandfathers, grandmothers, can make investments with a reasonable degree of certainty in what is, in fact, a gamble. You are totally correct. But a gamble is different than a swindle. And that's what the government is trying to prevent, right? A gamble is, either you're not good at statistics and so you placed a bet. A swindle is they change the statistics on you, right? And therefore you can't, even if you knew the statistics and you understood the bet, you were tricked into making the bet. So if you are traded on the stock exchange, if you have a publicly traded company, then you are required by the SEC, which is a government, it's a Securities and Exchange Commission, a federal government agency, to make certain public disclosures and filings. You have to make yearly disclosures, and then you have to make quarterly disclosures. And the whole point is so that investors are never going to sit down in your boardroom and ask you questions. So this is asking those questions on their behalf. And you have to make affirmative statements explaining what potential things could happen that are reasonable, or things that are currently happening that are going to affect the value of your company, right? So companies have to disclose something like a giant lawsuit against them that's pending, and explain, here's what the lawsuit is, and here's like how much money we could lose, and this is what would happen to our stock, so that you are plugging it into your statistics formula and you say, okay, this has become a less good bet, right? If a company intentionally lies in one of those disclosures, then they have committed a violation of SEC laws, and that violation can be the basis of a lawsuit by its investors, right? Because now you're basically per se, which means by definition, liable for this company lying. So there's two ways you can lie under the law. One is just to straight up say a mistruth, right? So you all can see me and you can see my background. If I said I'm wearing a black suit and I'm sitting in front of a beach, I'm clearly lying. Those things are not true.
Either that or using really good AI.
So, I mean, I think you guys know me well enough to know that I had to actually stand in front of a wall with a tiger on it to have a tiger behind me.
There are people that already asked on the Discord, is that real, or is that a virtual background? Like, there's shadows on it. I think it's real. It was hilarious. That was 5 minutes of conversation, just FYI.
The second way you can lie under the law is something called the material omission, right? So first thing is, whatever the lie is about has to be material, which means it has to matter, right?
Wait. You're telling me that the law is Catholic? Sins of omission and commission?
Exactly. So a material omission is something that you would have wanted to know, and I left it out. So for example, I'm selling you my amazing 2008 Subaru Outback. I tell you all these great things about it. I leave out the fact that the brakes haven't worked in 3 years, right? That is a material omission. It's material because a reasonable person would have wanted to know that, and I just left it out. I didn't say to you the brakes are great. I just didn't say anything about the brakes at all. So there's two theories that the class action lawsuit is proceeding on, and it's important to understand that it's a lawsuit. They've not won. They're testing these theories. So all of your questions, Josh, are the ones that are being brought in a court of law. And now we're sort of stretching the law over the existing dynamic cyber security hacking world, right? We're trying to figure out whether the current existing law fits, right? And so the theory that these investors are proceeding under is, when you made your disclosures, you should have known, right? You should have known how vulnerable the product you were putting out there is. Maybe you did know, right? And they're saying maybe you did know because when you start a lawsuit, you don't have a lot of information about what the other side has, right? You have to have enough to make a claim so that you can get to what's called discovery, when you could start finding out what they have. But like, how are you really going to know what somebody else knew when you start? So you could say they should have known, which they did. They're also saying that the fact that the SolarWinds password for their server was like SolarWinds 123.
Oh dear God.
In and of itself, I know you guys have just started sweating when I said that, is in and of itself proof that they were negligent. right? So that's going to be an interesting issue that comes up and gets tested in this case. Is that enough? Is having like a, your grandfather's password, is that per se negligence? Did they need something more than that? And then the other sort of theory they have is that after they found out there was a problem with their upgrade, they continued to sell their product, which is, I think, the Orion product. That is a much better theory, because that shows at that point that they did know. But all of this is going to the question for those of you out there of, when do you become liable, right? In a world of constant evolution and hacking and innovation, what are you supposed to know could happen? And how are you supposed to protect against that? So I find all of this really fascinating. So we don't know yet, because of the class action lawsuit was just filed. We don't know how any of these theories are going to go. We don't know yet what SolarWinds actually knew, or what their response is going to be as to why they maybe shouldn't have known, right? Maybe they weren't negligent. Maybe their defense is going to be, this could happen to anybody. And if we're liable, everybody who eventually gets hacked is liable. I don't know, but this is going to be fascinating to follow, especially because of the end user companies that are involved, the US government, Microsoft, who are going to be really motivated to say something here, right? So this isn't just a tiny company and their 5 or 6 investors. You have a lot of interested parties. So I'm really excited about the issues that are going to come out of this.
For those of us who do service work inside of the security community, we look at this and we're like, actually, that's not too terrible. They had an uppercase, they had a string of letters, and they had a couple of numbers. So they may have been meeting their own complexity requirements inside of SolarWinds. And that is something that should be discoverable and brought to light. Like, is there more that they could have done? Yes, of course, we all sit back and say, well, having an FTP server with a legacy username and password, what happened to 2FA, but 2FA on FTP. And then you start getting into the quagmire of, what does the policy and procedure and the engineering look like? How did all of that come together to precipitate the availability of these deployment packages to customers, right? How much are they putting in place of to be able to get this out with ease of deployment, ease of use, so on and so forth? So taking SolarWinds' side of the argument, I would say that they actually, depending on, and I don't know, depending on their policies, they actually may have met their own internal regulatory controls per their own compliance team.
So Scott, that's a great point, because so in law, there are things that are under the purview of experts, and then there's stuff that lay people know. And expert testimony is only allowed when it's required, and it's required when the regular person, I always think of like whoever's in your subway car that day. I'm a New Yorker, so that's why I always think of like the everyday person. If everybody on the subway car doesn't know exactly what you're talking about, you need an expert. And under the rules of evidence, there's sort of 2 standards of when expert testimony comes in. And one thing that you need for expert testimony to be allowed is some kind of agreement within that community of what the standard is. And so that issue you raised is so fascinating to me, because right now we're all having an active live conversation. SolarWinds may have created their own standard, and that password may have passed it, but is there a general standard? Is there just, we could take something totally different. Orthopedic surgery, right? That has been around for quite a while, and there's a standard by which you can have an orthopedic surgeon look at a surgery that was done and say, that is not the standard by which all of us do it, right? Or that's below the standard. But in the world of SolarWinds, right, or companies like SolarWinds, they all have an interest in having secrets, right, of doing things their own way, having their own secret sauce. There isn't right now, as far as I know, some sort of national expert standard that exists by which you can compare what they did to say, did they fall short of it or not, right? It's not like, you can, there's construction outside of my building. You could see right now what they're doing. And then there's a whole giant book of New York City standards of construction code, and you can compare what they're doing with that code and know, are they up to code?
So Priya, that's been actually a very long running debate in InfoSec. Is if we have standards, then we have to license people. If we license people, there's people that are going to license just for the test or study just for the test and not actually know what they're doing. It's the constant battle we have between certifications, licensure, and knowledge, and the fact that our field moves so fast. Construction changes. Don't get me wrong. My dad actually is an expert in this. He's been reading. He's an engineer, mechanical engineer, reading building code, going to court. He's an expert witness. So right up your alley for the last 50 years. But the building code changes over years and decades and literally centuries. Okay, our industry changes over hours and days and minutes.
Exactly, and what you said is exactly right. People who become certified experts have a duty. Lawyers have a duty. We have to do continuing legal education. Even that's far behind, right? Like the law is. If I was going to be a cybersecurity lawyer, then I would basically have to spend every morning reading what's happening, because by the evening, things could have changed. And so for me to actually stay up to code I don't even know how anybody would enforce that. So exactly what you're saying, construction changes, but it changes at a completely different pace than cyber technology is changing. And so there's so many issues that are going to come up in this case. Do we have experts? And then, as soon as we have experts, we're going to have someone trying to set the bar even higher, right? Somebody will crack that code. And then how do you recertify everybody? Yeah, it's so complicated that I'm curious to see how a bunch of 800-year-old judges figure out what the right thing is to do here.
It's going to be an AI judge.
Oh, don't go there, Scott. Oh God, just don't. Oh no. Okay, enough.
No, like when you look at cyber, Priya, to add to what you're saying, when you look at cyber, you're 100% correct. It moves at a lightning pace. There are more than enough people. Side note: there are more than enough people that I know that can't spell CISSP, let alone think that it actually holds its weight and value. When looking at the speed of maturation inside of the community, there are certain aspects of that get left behind in the wind. Sure, blockchain and AI is all shiny, new, bright, great stuff. Oh, we're using blockchain, realistically, where's the legal on this? Where's the compliance? And I would actually say that if you put out a timeline of speed where cutting edge is on one end and monolithic CFAA is on the other end, where do the pieces fall in on that timeline? I would say that compliance is actually ahead of legal, which is closer down towards CFAA, as in being the last thing to actually catch up. But the legal, what a lot of people don't understand, and correct me if I'm wrong here, the legal has the biggest impact across the entire timeline of cyber.
It does, right? And actually what you just captured is one of the greatest inefficiencies of the system, right? If you think about like a related rates problem, let's take a barrel with holes in it of different sizes, right? It's got a zillion holes that are really tiny, which is the cyber world, right? It's just shooting out all these places. And then it's got these like teeny, tiny prick holes of law trying to catch up, right? And so by the time the law gets involved, the thing has already happened, right? Mm-hmm. By the time the district court, which is a federal court, decides the SolarWinds class action, the cyber world will have moved on, right? So law only deals with things historically. That's one of the major principles of jurisprudence, which is you can't bring a case unless there's an actual controversy happening, right?
Right.
I mean, that's I'm going to get a little bit boring for a second, but sorry?
I said, and then you add ex post facto on top of it, so after the fact.
Well, you've got to be after the fact to bring a case.
What they're trying to decide right now might not even apply by the time they've decided it. Like everybody may have moved on, and something we couldn't have imagined is now being used. And so the law is always trying to decide in the past what happened and how did it fit with the rules that were there at the time. And by the time these judges make a decision, Congress could have changed the rules and the technology being used could be unrecognizable. So the SolarWinds case might not even have any precedential value on anything that happens either legally going forward or in the actual tech world. So all of it is really fascinating. The paces at which people are moving in this are almost comical.
Through SolarWinds,
this really goes.
I'm sorry. Go ahead, Josh. I apologize.
Thank you. No, it's okay. I really want to point out that in the Discord, people have been talking about cyber insurance and certification and things like that. And I want to go back to the cyber insurance for a second, just to point out that one of the problems with cyber insurance is the actuarial data. They don't have enough actuarial data, knowledge of what happened to make actual premium decisions, to understand how to price the risk moving forward. And your point about the law can't even catch up. We can't catch up because we don't have the data, the understanding of what goes on, and things change so fast. I think what you're saying is that for both law and for cyber insurance, for these things that act as reactive, I think would be a reasonable term to use, it's very difficult in a field that keeps changing so fast to be reactive. There's no way to do it, really.
Precisely. And then I actually almost feel sorry for the SolarWinds people, because when they put out their statements that the SEC requires them to put out, they may have been pretty good for the time, right? But now we just have a lot more information, and it's sort of like, COVID, right? Now, a year later, we all know a bunch. But in the beginning, many of us walked around without a mask because we didn't get it, right? And so now you can look at that behavior, you can be like, well, aren't you stupid? It's like, well, that was actually the best information I had in that moment.
At the time,
And like, how can you go back and criminalize when the data wasn't there? So the statement that SolarWinds made about their own exposure to risk, that's the basis of this lawsuit, may not have been wrong at the time, right?
Wow.
So it is fascinating. It is really fascinating. But on the AI issue, I don't know if you guys want to stick with this, but I know, Josh, that you were interested in the AI issue from the other two cases that also touch on the CFAA.
Yep.
Move on.
Well, if you're a part of the Discord, see, this is why you need to come and join us. The cases that we are referencing and everything that we're talking about are up in the Discord chat. So if you get a chance and you're hearing us, come over to Discord, go into SCW, scroll up, and you'll be able to read the case history. Go ahead.
So last year we talked about the CFAA, which is technically a criminal statute that is more or less the computer anti-hacking statute. And we talked about it in the case that's sitting in front of the Supreme Court still. That's the case of Van Buren, where this cop who had access to the DMV database legally used that access to basically sell information to some scumbag friend of his for a purpose that he wasn't allowed to. So what the Supreme Court is still deciding is whether someone who had authorization to access data in a computer system but used that data for an illegal purpose has violated the CFAA. So there's two, and that case is still sitting in front of them. While it's sitting in front of them, there's two new questions that have come up with the CFAA, which are only sprouting up because of all the things we've just discussed, which is that technology is moving at a lightning pace while law moves at a glacial pace.
Hey, Priya, why don't we actually stop for a quick second? Let's take a quick break and then come back to those two cases that you mentioned right after the break. That way we have a nice fresh start. Does that work for you?
Totally. How long will the break be, by the way?
If you need a bio break or a drink, it'll be plenty of time for that.
Perfect.